It is now my great pleasure to introduce my colleague and friend, Randall Kennedy, who will open our discussion and then join Michael Klarman in a conversation. The Michael R. Klein Professor of Law at Harvard University, Randall Kennedy is a scholar and widely cited commentator on race relations and civil rights law. After earning his law degree from Yale University, he served as a law clerk for Judge J. Skelly Wright of the United States Court of Appeals from 1982 to 1983, and for Justice Thurgood Marshall of the U.S. Supreme Court from 1983 to 1984. Professor Kennedy is the author of 4 books, including The Magisterial Race, Crime, and the Law, which I still assign in my undergraduate class every year, as well as more recently Interracial Intimacy, Sex, Marriage, Identity, and Adoption in 2003, and most recently in 2008, Sell Out, The Politics of Racial Betrayal. He is currently at work on a book on race relations and the Obama presidency that should appear this fall. He was elected a Fellow of the American Academy in 1998. I'm very pleased to introduce to you all Randall Kennedy.
Thank you. I'm delighted to introduce my colleague and friend, Michael Klarman. Professor Klarman got his undergraduate education at the University of Pennsylvania. He attended Stanford Law School, and after that was a Marshall Scholar at Oxford, where he received his D.Phil. He clerked for then Judge Ruth Bader Ginsburg when Judge Ginsburg sat on the United States Court of Appeals for the District of Columbia Circuit. And after that stint, Michael Klarman became a much celebrated member of the faculty of the University of Virginia School of Law. He is now the Kirkland and Ellis Professor of Law at Harvard Law School. Over the past several years, he has written any number of articles and book chapters. He's written several books. My favorite of the books he's written is one that won the Bancroft Prize in 2005. It's called From Jim Crow to Civil Rights, the Supreme Court and the Struggle for Racial Equality. There were a number of nice things that were said about this book. I'll just read one because I know the author of this encomium quite well. This is what was said about this book in the pages of the New Republic. Klarman's study is a major achievement. It bestows upon its fortunate readers prodigious research, nuanced judgment, and intellectual independence. I'm sure that these are traits that will be bestowed upon us this evening, and it's my great pleasure to cede the floor now to Professor Michael Klarman. Thank you.
I'm going to talk to you tonight about the Supreme Court and race. I'm going to give you a brief historical overview, and then I'm mostly going to focus on developments in the last 40 years, since 1970. There'll be a few takeaway lines after I offer my description, and I'm going to try to get this done within 30 minutes so that there'll be plenty of time for some discussion with Randy and then questions from the audience. So I want to start with a conventional wisdom, and then I want to try to debunk that conventional wisdom. The conventional wisdom is that the Supreme Court is a heroic defender of the rights of racial minorities. That's because the justices are somewhat insulated from politics. They're not directly politically accountable. That allows them to have some element of independence and enables them to protect minority groups against majoritarian oppression. I want to challenge this idea that the court has historically played this role. Indeed, I want to argue to the contrary, that the Supreme Court, more often than not, has been a foe rather than a friend of racial minorities in general and African Americans specifically. Before the Civil War, the United States Supreme Court upheld federal fugitive slave laws against constitutional challenge. The court struck down northern state personal liberty laws that tried to protect African Americans from kidnapping. In the famous Dred Scott case in 1857, the court both held that Congress lacked the constitutional power to restrict the spread of slavery into federal territories, and the court held that even free blacks did not have any rights that white people were bound to respect. During and after Reconstruction, the court invalidated federal civil rights legislation. The court allowed perpetrators of racial massacres and lynchings of African Americans to go free on legal technicalities. Well into the 20th century, the Supreme Court generally upheld laws segregating the races and sustained Southern state measures addressed toward the disfranchisement of African Americans. It's really Brown versus Board of Education in 1954 and its immediate progeny that are responsible for this romantic image we have of the Supreme Court as a savior of the interests of African Americans. Now, to be sure, the court's ruling in 1954, which struck down state-mandated segregation in public education, was of enormous symbolic importance to African Americans. Many contemporary African American newspapers referred to Brown as the most important event for blacks since the Emancipation Proclamation. By making Jim Crow seem more vulnerable, the Brown decision raised the hopes and expectations of African Americans and thus helped to catalyze the transformative civil rights change that came in the 1960s. Yet, one should not exaggerate the contribution that the Supreme Court made to progressive change in the 1960s. The Brown decision reflected social and political changes with regard to race at least as much as the decision made such changes possible. The ruling would not have been conceivable without the tremendous impetus for racial change provided by World War II. The anti-fascist ideology of the war, the contributions made by black soldiers to this war for democracy, the increasing migration of African Americans from the rural South to the urban North, where they exerted much greater political influence, and finally, the Cold War imperative for racial change that followed the war, that is, the perceived importance for the United States to eradicate Jim Crow as a way of appealing to third world nations, which are mostly non-white, to side with democratic capitalism in the battle with communism. All of those forces laid the groundwork for the Supreme Court's decision in Brown. Moreover, the court followed its bold pronouncement in the Brown 1 decision in 1954 with a ruling that was so weak and vacillating in Brown 2 in 1955 that I think the court actually led white Southerners to believe that it was possible to intimidate the justices into eventually backing down from their decision. After Brown 2, the Supreme Court essentially vacated the field for the better part of a decade. The justices apparently concluded that they did not have sufficient backing in public opinion or from the president or from Congress, and they concluded that they had no useful role to play until that sort of support was forthcoming. There was no such immediate show of support. As a result, as late as 1964, a full decade after the decision in Brown, as few as 1 or 2 in 100 African American school children were attending integrated schools. 1964, a full decade after the Brown decision. Now, as the direct action phase of the civil rights movement, the sit-ins, the freedom rides, the street demonstrations began to sweep the nation in the early 1960s, the Supreme Court re-entered the fold. The court again exerted itself both with regard to school desegregation specifically and with regard to other racial issues more generally. In 1963, the court warned that the desegregation context had been significantly altered from what it was in 1954, 1955, and that desegregation plans that might have been deemed sufficient 8 or 9 years earlier no longer would necessarily be so. In 1964, the justices ruled that school closures taken for the purpose of avoiding desegregation orders were unconstitutional. And in 1968, the justices in a case out of Virginia held that the constitutionality of school desegregation plans would depend not on whether they formally desegregated the schools, but whether they actually achieved a significant measure of racial integration. During the 1960s, the court also went to great lengths to overturn the criminal conviction of sit-in demonstrators. The court created new constitutional law to protect the NAACP against legal harassment by Southern states. The court expanded the range of private actors which are bound by the anti-discrimination provisions of the 14th Amendment, and the court upheld broad exercises of congressional power on behalf of civil rights. In addition, the Warren Court justices revolutionized the rules of criminal procedure, and criminal defendants disproportionately belong to racial minority groups. And the court also radically transformed the law of federal courts because the justices no longer believed that Southern state judges could be entrusted with fairly dealing with the civil rights of Southern blacks and whites. For this short decade of the 1960s, the court came about as close as it ever has to realizing this image of heroic protector of racial minorities. Then, just as the civil rights movement reached its zenith, shifting social and political forces disrupted racial progress. Opinion polls had shown that civil rights was the predominant issue on the national agenda from the spring or summer of 1963 through the spring of 1964, but at that point, the Vietnam War displaced it from the #1 issue on Gallup polls. Moreover, as civil rights leaders began to shift their focus from the South to the North and broaden their agenda to include economic empowerment, many previously sympathetic whites lost their enthusiasm for the movement. Less than 6 weeks after President Lyndon Johnson signed the Voting Rights Act into law, a race riot erupted in the Watts neighborhood of Los Angeles, killing 34 people, and that proved to be the harbinger of dozens of other race riots in American cities later in the 1960s. By the mid to late 1960s, black nationalism, which often eschewed racial integration as a goal and nonviolence as a tactic, was sowing divisions within the civil rights community and souring many white Americans on racial reform. Indeed, one can see the white voter backlash erupting as early as 1964 in national politics. That's the year the Republican Party nominated Barry Goldwater for the presidency. Barry Goldwater was a vocal opponent of that year's Civil Rights Act, and in the 1964 election, he won 5 Deep South states and his home state of Arizona, accelerating a transformation in national politics that we still see to the present day. Blacks deserted the party of Lincoln in droves, and those whites most committed to the preservation of white supremacy switched 100 years after the Civil War from being reliable Democrats into being reliable Republicans. By 1966, a racial backlash was appearing in the North as urban race riots, proposals for fair housing legislation, and demands by African Americans for economic empowerment were starting to sunder the civil rights coalition. In 1968, Republican presidential candidate Richard Nixon won the presidency on a domestic platform of law and order, a reduced a relaxed pace of school desegregation, and an end to busing. 97% of African Americans voted for Hubert Humphrey in 1968. Only 35% of whites did so. The 14% of voters who supported the notoriously racist George Wallace, who was running on an independent party ticket, those 14%, provided an additional future temptation for the Republican Party to move even further to the right on race issues. Nixon's victory at the polls translated directly into changes in the court's racial jurisprudence. He got 4 new appointments to the court during his first term. Nixon's appointees quickly made themselves felt with regard to the court's racial jurisprudence. In 1974, the Supreme Court decided in its most important race decision, most important school desegregation since Brown, a case out of Detroit called Milliken versus Bradley. The court ruled by a 5-4 vote that largely white suburban school districts could not be drawn into an urban desegregation decree unless there was proof that school district lines had been drawn with the deliberate purpose of preserving racial segregation. As a result of this decision, federal courts were disabled from accomplishing meaningful desegregation in most American cities. In most American cities, whites were fleeing the cities to the suburbs. It was not possible to have meaningful desegregation if you walled off the suburban school districts from the urban district. Nixon's appointees were 4 of the 5 justices in the majority in Milliken versus Bradley. On another issue of tremendous racial importance, the Burger Court ruled in a case called Washington versus Davis in 1976 that laws that did not make a racial classification, that is, laws that on their face say nothing about race, those laws would receive heightened judicial scrutiny, the most intensive form of judicial review, only if the plaintiff could prove that they had been motivated by a discriminatory racial purpose. It was not sufficient to show that those laws simply had a disparate impact on racial minorities. So to give you an example of what's implicated by that decision, as a result of that ruling, federal sentencing guidelines that prescribe precisely the same punishment for possessing 5 grams of powder cocaine as 5 grams of crack cocaine as for possessing 500 grams of powder cocaine. Those laws have survived constitutional challenge, even though 90% of the crack defendants are black and 3/4 of the powder defendants are white. An enormous disparate racial impact, but under the Supreme Court's racial jurisprudence, not unconstitutional unless you can show that a discriminatory racial animus is what produced the law. In the 1978 Bakke decision, the Burger Court narrowly ruled that race-based affirmative action policies would be subject to the same strict judicial scrutiny as traditional Jim Crow legislation. Conservative justices then and since have read the 14th Amendment as a command of colorblindness. That's a 14th Amendment that was adopted for the purpose of guaranteeing civil rights of recently freed slaves. These justices have read it to mandate colorblindness in the context of racially motivated measures designed to redress past discrimination. The court's overall record on race-based affirmative action is mixed. Since the Bakke decision, the conservative justices have almost invariably voted to strike down affirmative action measures, while the liberal justices have almost always voted to reject constitutional challenges to those measures. Individual case outcomes have been determined by the swing justices, first Justice Lewis Powell, then Justice Sandra Day O'Connor, but it would be fair to say the court has invalidated more affirmative action laws than it has sustained. This hostility of the conservative justices to race-based affirmative action reflects what I would call a constitutional double standard. These are the same justices who ordinarily, for example, in cases involving abortion, cases involving gay rights or physician-assisted suicide, profess commitments to judicial restraint, to democratic decision-making, respect for states' rights, and a commitment to a constitutional methodology of textualism and originalism. Yet all of those considerations point in the favor of the court permitting race-based affirmative action. When the court strikes down affirmative action programs, it is unelected justices striking down the democratically chosen policies of state and local governments, and they are doing it on a thin constitutional basis. The text of the 14th Amendment doesn't say anything about government colorblindness, and the original understanding of the 14th Amendment, which these justices ordinarily profess a commitment to abiding by, does not mandate colorblindness. The people who wrote the 14th Amendment and their constituents were actually, perhaps ironically, too racist to support a complete ban on government racial classifications. We know, for example, that they thought that laws disenfranchising blacks were not forbidden by the 14th Amendment. That's why a 15th Amendment was necessary a couple of years later. They did not believe that excluding blacks from jury service violated the 14th Amendment, and they did not believe that laws forbidding interracial marriage or laws mandating segregation of schools violated the 14th Amendment. It is impossible, I would submit to you, to derive from the 14th Amendment a mandate for government colorblindness. The Rehnquist Court, which succeeded the Burger Court, pretty consistently ruled against the interest of racial minorities, although most of its decisions were divided narrowly along partisan lines. Since Presidents Ronald Reagan and George H.W. Bush appointed 5 new justices to the court between 1981 and 1991, conservatives have enjoyed a secure majority on almost all racial issues, although interestingly, not on many other issues such as abortion, gay rights, the death penalty, or the separation of church and state. By 1991, the last 10 appointments to the Supreme Court had been made by Republican presidents, none of whom garnered much more than 10% of the African American vote in their presidential election victories. It was the Rehnquist Court, the Rehnquist Conservatives Court, which sounded the death knell for court-ordered school desegregation. In a case from Oklahoma City in 1991, a narrowly divided court ruled that once a school district had complied in good faith for a reasonable period of time with a court-ordered desegregation decree, and if it had eliminated to the extent practicable the past effects of deliberate state-sponsored discrimination, then the school district was entitled to be released from its court-ordered desegregation decree. If terminating a desegregation decree under those circumstances resulted in increased school segregation, which it almost invariably did, then private housing preferences were responsible, the conservative majority said, and you could not fairly ascribe responsibility to the ensuing school segregation to the government. In 1995, the conservative justices indicated that their tolerance for alternative remedies, alternative to busing, alternative remedial decrees involving increased funding to compensate for past discrimination, that those were also unlikely to satisfy the court's scrutiny. In a 5-4 decision, the Supreme Court forbade the use of magnet school programs for the purpose of enticing suburban whites back into urban schools, and the justices imposed virtually insurmountable obstacles to judicially mandated increases in educational financing as a remedy for school segregation. In addition to curbing court-ordered school desegregation and race-based affirmative action, the Rehnquist Court's conservative majority inaugurated a new strand of constitutional jurisprudence that called into question the permissibility of legislative districts that had been deliberately gerrymandered to enhance the ability of racial minorities to elect representatives of their own race. As with the conservative justices' posture toward affirmative action, these decisions are very difficult to reconcile with the original understanding of the 14th Amendment, which quite clearly was meant not to cover political rights, but only the civil rights that distinguished former slaves from free persons. Perhaps most disturbing, the Rehnquist Court has proved largely indifferent to race discrimination in the criminal justice system. In a 1987 decision called McCleskey versus Kemp, the conservative justices narrowly rejected, again, a 5-4 decision. They rejected an equal protection challenge to the discriminatory administration of the death penalty in the state of Georgia. Specifically, according to a study that the justices stipulated they were accepting the validity of for purposes of the litigation, defendants who murdered whites were 4.3 times more likely to get the death penalty in Georgia than defendants who had murdered blacks. In other words, Georgia was essentially devaluing the lives of its African American citizens by refusing to administer the death penalty as aggressively when it was blacks who had been killed as opposed to whites. Rejecting the constitutional challenge, the court said that race discrimination could not possibly be entirely eliminated from the administration of the death penalty as long as actors who were integral to the administration of the death penalty, like jurors and prosecutors, continued to exercise significant discretion. And the majority also noted that similar racial disparities probably existed throughout the criminal justice system, which meant that vindicating McCleskey's claims would have profound consequences throughout the system. One might have thought that that observation made McCleskey's claims more compelling, but the court thought they made them less compelling. In 2007, another slim conservative majority brought the court's racial jurisprudence full circle from Brown. In 1954, the court had ruled that state-mandated racial segregation in public schools violated the 14th Amendment. In 2007, the conservative majority, in an opinion written by the new Chief Justice John Roberts, ruled that for school districts to take race into account in order to promote the goal of racial integration violated that same 14th Amendment. Now, the conservative majority in this 2007 case, which is known as Parents Involved, they did not talk about the text or original understanding of the Constitution. They talked about a supposed mandate for colorblindness, but they did not try to root it in the text or original understanding, probably because, as I've already suggested, it is almost impossible to root such an understanding in the text or original intent. Instead, the conservative justices relied mostly on Brown versus Board of Education and extraordinarily on the NAACP's argument to the Supreme Court in Brown, which is an unusual source of constitutional interpretation, to say the least. I can't think of other examples where the Supreme Court relies on the arguments that a past litigant made to the court in a prior case as a source of constitutional interpretation. Now, Brown, of course, does not have to be read as a mandate for government colorblindness. Indeed, it can just as easily be interpreted to forbid only those racial classifications that were adopted for the purpose or that have the effect of subordinating traditionally disadvantaged racial groups. It's true that the NAACP in Brown did argue, at least in portions of its brief, for government colorblindness, but that's not what the court gave the NAACP. The justices in 1954 were too wary of striking down anti-miscegenation laws. That was an especially explosive issue in the mid-1950s when opinion polls showed that 90% of the country, North as well as South, opposed interracial marriages. The justices were too worried about striking down bans on interracial marriage to give the NAACP a flat-out ban on racial classifications. Moreover, the conservative justices in 2007 were taking the NAACP's argument in Brown badly out of context. The NAACP had argued for government colorblindness in the context of a system of formal Jim Crow white supremacy. To portray the NAACP as repudiating race-conscious government efforts to redress past discrimination, to promote racial diversity, in a setting where nobody could have dreamed of legislatures adopting such measures, which is the case in the 1950s, I think that is quite disingenuous. I would draw three lessons from this brief historical journey that I've just led you through. What should we conclude from the last 40 years? First of all, most of these rulings were 5-4. Had there been one more liberal justice, many, if not most of these decisions would have come out differently. Thus, it was not in any sense predestined that the United States Supreme Court would, for the most part, reject race-based affirmative action, prematurely terminate the school desegregation project, or reject the argument that the Constitution bars not only discriminatory purposes, but also racially disparate impacts. Constitutional interpretation, I would suggest, necessarily implicates judicial discretion. Judicial discretion reflects political ideology, and conservative justices tend, not surprisingly, to reflect the conservative racial ideology of the party that appointed them. That ideology embraces a narrow, formalist understanding of what counts as race discrimination. It abhors the use of racial preferences, whether they are benignly motivated or not, and it deems this nation's ugly history of racial oppression as something more to be repudiated than to be remedied. Second, while the political composition of the United States Supreme Court is to some extent fortuitous, the victories of the conservative bloc of justices since 1970 has predominantly been a function of politics. Between 1969 and 2008, Republicans controlled the presidency for 28 years, Democrats only for 12. Of the 14 appointments made to the United States Supreme Court between 1969 and 2006, 12 of them were made by Republican presidents, most of whom prided themselves on their conservative politics. Because constitutional interpretation is so inextricably linked with politics, I don't think we should be very surprised that justices who were appointed by presidents for whom very few black people voted would decide race-inflected cases in ways that contravene the preferences of most African Americans. Third and finally, I think one has to wonder at least a little bit how much difference it would have made had the liberal justices had their way and had the decisions come out in the direction that the liberal justices would have favored. Public opposition to busing the suburbs was so intense by the early 1970s. Think, for example, of the race riots that erupted in Boston in 1974, Boston, the so-called cradle of abolitionism, that it's a little bit hard to believe if the Supreme Court had come out the other way in Milliken versus Bradley and approved of judicial busing of the suburbs, that the justices could have made that decision stick. It's quite plausible that there would have been a constitutional amendment or that there would have been massive defiance of such a decision. A conservative majority of justices, it's true, has managed to invalidate most affirmative action policies that have reached the court. But even when the liberals have won an occasional triumph, such as the University of Michigan Law School case from 2003, that result has been overturned at the polls, as it was in a referendum in Michigan a couple years later, because most Americans seem inclined, when asked to vote on the topic, they seem inclined to vote against race-based preferences. Similarly, by the time the court in 2007 struck down school board policies that took race into account with the aim of promoting integration, by the time the court struck those down, only 5 to 10% of school districts in the country had such policies. Most of the country had already given up on racial integration in grade schools. So to sum this up, in the last 40 years of conservative hegemony on the court, we have had consistently racially regressive results pretty much across the board, but one should not absolve the larger society that the court serves of its share of responsibility for those outcomes. The United States Supreme Court mirrors American society at least as much as it shapes it. The conservative justices could not have foisted this conservative racial jurisprudence on the American people without their acquiescence. Thank you very much.
Well, thank you very much, Professor Klarman. I'm going to kick things off here. We have a nice intimate group here. We can have a good, full discussion. I have one comment and two questions to start things off. A comment is this. I'm very sympathetic to your debunking spirit and think that there's far too much Supreme Court worship. We see it all the time. We see it certainly at every confirmation hearing of a person who wants to be elevated to the Supreme Court. We see this insistence by everyone, the nominee, the senators, the president. We see this insistence upon distinguishing between politics on the one hand and law on the other. So there's this mantra, of course, about the person who wants, the nominee, insisting that he or she will, as they say, interpret the law and not make the law. We hear that over and over and over again. We also see this cult of the court in journalistic conventions. So, for instance, I mean, it seems like every day when I'm listening to news reports, there is talk of the government over here, and then there's the courts over here, as if the courts are not part of the government. It's a convention, but I think it's a convention that you hear over and over and over again, and it has its effects on the way in which people think. Now, here are my two questions. One, where does the cult of court worship come from? And why does it hang on, given the history that you offer? I mean, there are lots of Brown versus Board of Education certainly helped put a halo over the Supreme Court, but Brown versus Board of Education is several decades in the past. So why, in light of the history that you have detailed, why is it that it is still the case, as you indicate from the outset, why is it still the case that there are many people, including racial progressives, who insist that the court is somehow special, who insist that the court has to be or should be as a matter of sort of almost institutional design, a friend of racial minorities? What explains that? Second, would it be good for racial progressives to do what you've done? Would it be good for racial progressives to engage in a systematic debunking of the court? One of the things that prompts me to ask that question is the attitude that was taken by one of the judges for whom I clerked. I clerked for J. Skelly Wright, a crusading liberal judge, a judge who desegregated the New Orleans school system and for his efforts had his family put under armed guard for a couple of years. When I clerked for Judge Wright, the people in legal academia about whom he was most concerned, the group at which he was most angry, was critical legal studies and other radical legal realists. And I asked him about this. It seemed sort of strange given his politics. Why was he so angry at them? And he said, well, the reason why I'm so angry at them is because in their debunking of the courts, if people, his position was, we want the populace to obey the courts. Because if the populace does not obey the courts, when the courts rule, as in Brown, the people won't listen. And frankly, he was more afraid of white populism than he was afraid of the tendencies that were the subject of your talk. His view was that, you have to, what are you most afraid of? And he thought that racial progressives would get more from the rhetoric of rule of law, of constitutionalism, of, frankly, court worship. He thought that they would get more out of that than they would out of a realistic view of the court system. So what do you have to say about those two things?
Okay. Two things plus a comment, right? So Those are great points. Let me start with the comment. I would distinguish a little bit between formalism and court worship. I think what you were describing most was a formalistic understanding of what judges do, which is, as Chief Justice Roberts said in his confirmation hearings, calls, balls, and strikes. As Justice Sotomayor said in her confirmation hearings, empathy has no place, we follow the law. That's formalism. That's the idea that judges can be umpires, they can be automatons. Nobody who studies constitutional law in the United States could, I think, realistically believe that judges are not making as much law as they are interpreting law. So on every major issue of constitutional dispute in the United States, abortion, school prayer, affirmative action, the death penalty, the separation of church and state, federalism, whether the Supreme Court should intervene in the Florida recount, almost every imaginable issue, the court divides 5-4. And it's not because one set of justices is following the law and the other set is making it up. It's because politics necessarily is implicated in constitutional interpretation. So I would just reject the formalist stuff as a kind of pretense that goes on in Senate confirmation hearings, but everybody on the Supreme Court, all those justices are bright enough to understand that that's not really what they do, that when they decide that campaign finance regulation is unconstitutional, that they are expressing political disagreement as well as legal disagreement. I don't know whether court worship is necessarily tied up with formalism. I think you can be a legal realist and believe that judges exercise discretion, or you can be a formalist and think judges don't exercise discretion and still believe in court worship. So I think those might be two separate points. Now, the cult of court worship, this idea that the Supreme Court is responsible for protecting our liberties, that if we didn't have a Supreme Court, we wouldn't have a right to free speech, we wouldn't have racial equality, we wouldn't have gender equality, and so forth. I'm not sure I have a great explanation. I think that's mostly rubbish. I think the Supreme Court operates at the margin, and we'd have largely the same society with some marginal differences. There are lots of countries around the world that we recognize as being essentially as free, essentially as egalitarian, who would never dream of entrusting this much authority to judges interpreting a constitution. Part of the myth about Brown is that people like founding myths, so that in the same way people like to believe that a guy named Abner Doubleday invented baseball on a field in upstate New York. They like to believe that Brown versus Board of Education created the civil rights movement. It's much more complicated to believe that a variety of social and political forces, largely emanating from World War II, like the Great Migration, like growing black political power, like the role of African American soldiers, like the anti-fascist ideology of the war, that those sorts of things contributed to a powerful civil rights movement, and that Brown really was contributing to a movement that was already well underway. The justices themselves totally understood that. If you look at the internal deliberations in Brown, they're all saying things about how struck they are by how much the world of race is already changing. They don't think they're creating a movement for reform. Some of the myth may just be comforting. It's a comforting sort of story to believe that the Supreme Court will rescue us if we ever do anything awful. But of course, it's not true. We had slavery, we had white supremacy, we had Japanese American internment, we had McCarthyism. The Supreme Court did nothing to rectify any of those things, right? The court's interventions are marginal and they come after the fact. Even in areas like race, where the court decided Brown, the court had first decided Plessy. So the Supreme Court never is at the vanguard of movements for social reform. The court is always bringing up the rear. The other explanation would be the role of lawyers. Lawyers have a more profound role in the United States than in any other country in the world. And of course, lawyers are committed to this myth because it embellishes the role of the legal profession and the judiciary. So of course they want to believe that lawyers and judges and courts are fundamentally responsible for creating whatever civil rights and civil liberties we treasure. Racial progressives and debunking the court. I do believe quite strongly that progressives have been lured into litigation and that it's been a really fundamental mistake. Progressives fell in love with the Warren Court. They came to believe because of the Warren Court that the Supreme Court could fight their battles for them. The Warren Court was deciding issues in favor of progressives like separation of church and state, like protection of privacy rights, race issues, free speech issues, protecting criminal procedure rights. The Warren Court was adopting the agenda of the liberal wing of the Democratic Party, and I think it was easy to fall in love with judicial review in the Supreme Court. The problem is, I think, at least twofold. One is that the Supreme Court is not always going to be controlled by progressives. So we've seen that in the last 40 years when the court more often than not has been controlled by conservatives. But the other, maybe less self-evident, but more, I think, more consequential problem is that if you win in the court before society is prepared for the victory, you've won a hollow victory. And I think we've seen that on issues like abortion and the death penalty, where the Supreme Court in 1972 threatened to abolish the death penalty a little bit before the country was ready for it and created a massive backlash in favor of capital punishment. The Supreme Court struck down abortion with such a far-reaching decision in 1973 that it invigorated a right to life movement that previously had not played much of a role in politics. And you've seen the same thing in the last 6 or 7 years with regard to court decisions in gay marriage. These decisions have produced powerful political backlashes that have led to 30 states adopting constitutional amendments barring same-sex marriage and have had very beneficial effects at the polls for Republican Party candidates. The same thing was true with Brown. Brown had almost no effect in the South for 10 years. It wasn't till national opinion had gotten behind Brown that you got the 1964 Civil Rights Act, that you got legislation threatening to withhold funding from school districts that continued to segregate, legislation authorizing the U.S. Attorney General to bring desegregation lawsuits. It's only when Congress and the President and national opinion got behind Brown in 1964 that actual desegregation took place. So I think progressives, understandably but regrettably fell in love with the court in the 1960s, and that's a mistake. These battles have to be won in public opinion. It's not that the court can't play a useful role, but if you think you can win in the court and the country is going to blindly fall in line with the court's decision, there's just no reason to think that's true. That's never been true. People who lose in the Supreme Court rally in opposition and fight and struggle against the court. They don't lie down and roll over and play dead and say, now the court's told us what the rule will be, we're going to follow it.
Professor Klarman, your warning about the interplay of politics and the court is well taken. But I think you went astray when you tried to apply it to the world of other countries. In fact, you said you can imagine other countries adopting our system, whereas the truth is that since World War II, successively, many major countries that had never had a system of judicial review on constitutional terms have adopted it deliberately, following the American model. Germany has a constitutional court with a worldwide reputation and very significant decisions. South Africa, after the end of apartheid, adopted a system of a Bill of Rights and a constitutional court which has repeatedly held government actions invalid and has certainly had a profound effect on that society. And Britain has just recently written the European Convention on Human Rights into domestic law, giving the courts in Britain for the first time. And this is a really radical change, the power to declare legislation of Parliament inconsistent with the Convention. So I think you should drop that argument.
So my point was that there's no other country in the world where lawyers play the role that they play in the United States, and there's no other country in the world where courts interpreting constitutions have as much impact on public policy. And I'm going to stand by that point. It's true that since World War II, a great many countries, as you point out, have followed the American model, have written constitutions, have entrusted judges with the authority to interpret those constitutions. It's also true that many other countries have followed American social mores across a broad array of issues. McDonald's has exploded across the world as well. Other countries follow the United States for better and for worse. Other countries that have written constitutions and judicial review, none of them have entrusted to their unelected judiciaries authority over most profound social conflicts that arise. So the United States is the only country in the world where almost every issue of social conflict that you can imagine ends up getting resolved by the Supreme Court. The death penalty, affirmative action, gay rights, abortion, separation of church and state, whether we can limit spending on elections, whether presidential election recounts ought to take place in the state of Florida. Every one of these issues is resolved in the United States by courts. It's true that in other countries there is judicial review, that courts are starting to assume greater authority, but I'm comfortable with the claim that no other Supreme Court exercises that authority. Now, the other point that I would want to emphasize is there are lots of other countries that have written beautiful constitutions like the Soviet Union, and the constitutions don't really mean very much. So the point that I really want to emphasize is basic tolerance, protection of civil liberties and civil rights, they come from having a tolerant society. They might come from some of the basic insights James Madison had about the structure of government in the Federalist Papers, but they don't, for the most part, come from having nice words on a piece of paper being enforced by courts. The Supreme Court at most plays a sort of marginal role. Now, you might say those points are in conflict. I think there might be some tension between those 2 points I just made. One, the Supreme Court adjudicates every important issue, but two, the Supreme Court at most plays a marginal role because to a large extent the court reflects public opinion. There may be some tension there, but I think both of those points are for the most part right. And I think in the United States, more than anywhere else in the world, the courts really are taking over a very broad swath of jurisdiction. Whether it matters a huge amount depends on the other point, which is whether the court ever deviates that far from public opinion.
I would agree with the previous speaker about the South African case because, I think that what we are learning in South Africa is that the Constitutional Court, not the Supreme Court, in fact plays a huge role in enabling the agency of the marginalized in a whole range of ways. So on socioeconomic issues, on housing. I think that an understanding of these institutions of power as having the possibility to both hinder and enable the agency of vulnerable communities is absolutely crucial. So that's the one point. The other question I'd like to ask you, and my question comes from a very specific place because I live in South Africa and I engage with issues of affirmative action. I'd like to know your thoughts on the argument that race-based preferences require race classification, and race classification in turn reproduces ideas of race. Now, part of that argument comes from a colorblind perspective, but there is also an anti-racial argument that is often much more nuanced argument that is often misinterpreted, that argues roughly for the same, but that also argues, as I do in my own work, for looking behind the race categories, for what, lives behind them in order to create new indices of those kinds of inequalities. If you would kindly share your thoughts on that. Thank you.
Right. Let me say a word about the comment, and then I'll get to the question. I don't know enough about the details of South Africa constitutionalism. I don't have a sense of what it is that the South African court has done in any detail in the last 15 years. So I can't comment about whether the South African court has played a more constructive contribution. I would simply emphasize, you mentioned the point that the court can enable as well as hinder. I absolutely agree with that. The Supreme Court can do things that from a variety of political perspectives will seem either good or bad. My view is, I think I'm making the point that simply from the perspective of racial progressives or progressives of a broader stripe, it's not at all clear that judicial review over the course of American history has been more of a help than a hindrance to the cause of racial progressives. The Supreme Court, for the first 150 years of its existence, mostly involved itself in issues of economic redistribution, and it mostly intervened on the regressive rather than the progressive side. Between 1937 and 1969, the court was controlled by New Deal, Fair Deal liberals, who more often than not decided cases in the way that someone of my political ideology would agree with. In the last 40 years, the court, more often than not, has been controlled by conservatives, who more often than not decide cases in a way I disagree with. The same court that can strike down racial segregation, the same court that can strike down gender discrimination, can also strike down affirmative action. They can strike down New Jersey's attempt to require the Boy Scouts to admit gays. They can strike down campaign finance restrictions. They can hand the 2000 presidential election to candidate Bush over candidate Gore. There is nothing inherent in judicial review that would cut in a progressive direction. And even when the court does things that we would regard as positive from a progressive perspective, there are costs to that. One cost is that the court confers a certain legitimacy on the status quo after the court decision. So when the Supreme Court strikes down racial segregation and nonetheless African Americans continue to go to disadvantaged schools, schools that are unequal, it's a lot easier to say, well, the Supreme Court solved the problem in Brown. If you still have a problem, it must be your own fault. It can't be the Constitution's fault because the Supreme Court has cured the segregation problem. The other difficulty is when people rely on the court, they're not sufficiently vigilant. They don't seek to protect themselves as much in the political sphere. They don't try to mobilize as much socially. Now, I don't think that's actually true about the gay rights movement. I think the gay rights movement learned from what happened with Roe versus Wade that it's not enough just to rely on the Supreme Court. But it's pretty common in the pro-choice groups in the 1970s to reflect back on Roe and say what happened after Roe is we won this huge victory and then it became impossible for us to mobilize our supporters anymore because why should you go on fighting in 50 state legislatures when you already have the federal Constitution on your side? So I think there are costs to even when you win in the Supreme Court, and I'm not convinced that progressives are going to win any more than they're going to lose. It depends on who happens to sit on the court. Now, on the question, I'm not positive that I followed it entirely, but I'll try to respond to what I think I understood. Race-based preferences don't require racial classifications. You can adopt measures designed to promote the interests of racial minorities that are facially neutral. So take, for example, the Texas so-called 10% plan, where you stop using race-based preferences, and what you say instead is, we're going to accept the top 10% of every high school graduating class into the University of Texas, and we know that some of these graduating classes are going to be mostly Latino or mostly Black because of residential segregation. That is an effort to promote the interests of racial minorities without using a racial classification, and the Supreme Court suggested in the Michigan, at least at the oral argument in the University of Michigan case, that it much preferred that you use these kind of surreptitious, racially motivated efforts to promote the interests of racial minorities. Now, it's not clear whether the conservative majority would permit even those race-conscious but racially facial neutral measures. The division in the most recent case, this is the parents involved case in 2007, where the Seattle and Louisville school districts are consciously taking the race of students into account, trying to promote some semblance of racial balance. So there are lots of other factors they're using in allocating students, but the race of a student might end up being dispositive because they're trying to preserve some racial diversity in schools. The court struck that down by 5-4. The most conservative 4 justices say the Constitution requires colorblindness. The way to end race discrimination is to stop discriminating based on race. Justice Kennedy, who is the 5th vote on almost every issue, said that he might allow racially motivated but race-neutral measures, but he first wanted you to try to, he He might allow race-conscious measures, but he's not going to allow facially race-based measures unless you've first shown that you've exhausted all other alternatives. So Kennedy was very specific. If you want to have a magnet school program for the purpose of encouraging whites back into the urban school system, that would be fine with him. If you want to locate new schools in integrated neighborhoods rather than segregated neighborhoods, hoping they'll be integrated schools, that's fine with him. Chief Justice Roberts, Justice Scalia, Justice Thomas, they're probably going to strike that down as well, but Justice Kennedy will vote with the liberals. Now, there's a whole other question about whether race-based affirmative action is the right way to go or whether we should be focusing on class-based affirmative action. My view is we should do both. I see them as serving different objectives, but it's clear that it's a lot more politically sellable to have class-based affirmative action, and it's probably legally easier to justify under the Constitution. So if the University of Michigan wants to admit students from disadvantaged backgrounds, students who grow up in violent neighborhoods, there's no constitutional objection to that. But if they take race into account, today there are 5 votes to strike that down, because Justice O'Connor's not on the court anymore, and Justice Kennedy would vote the other way.
Bringing it locally now back to the United States. 2 questions for both of you, really. If the Supreme Court has not been the champion of civil rights in healing the racial polarity, et cetera, which would you, in comparing it to the other 2 branches, has been the better champion? That's the first question. And the second question is, can you identify the period, if we use, instead of Brown, Reconstruction as the epicenter for race in the law, where the Supreme Court has been most aggressive and progressive in advancing civil rights?
You want to go ahead?
Go.
Okay, I might have to ask you to repeat the second point, but I can try to answer the first, and then you can repeat the second, or maybe Randy wants to say something as well. So you're exactly right that we always want to ask the court as compared to who, and it's certainly true that the NAACP is litigating in the Supreme Court because the alternative is so unattractive in the 1950s. Now, sometimes the president was acting first. So Harry Truman did desegregate the military and the federal civil service by executive order. But it's not like Congress was going to pass civil rights legislation. It's not like Southern legislatures were going to desegregate. So you absolutely have to fight on whichever battlegrounds are most attractive. I think the point I would emphasize is, and Thurgood Marshall and his predecessor Charles Hamilton Houston totally understood this, you don't put all your marbles into one basket, and you don't see litigation as just about winning a case in the Supreme Court. Litigation for Charles Hamilton Houston and Thurgood Marshall was a method of mobilizing social protest. It was the best method available in the 1930s. You couldn't engage in sit-in demonstrations in the South in the 1930s because you would have been beaten up or killed. African Americans in the South couldn't use political power because they were disenfranchised. They couldn't use economic clout because they were mostly still sharecroppers and tenant farmers. You didn't have a lot you could do other than litigate. But they were very clear, and Houston says this all the time, we have to prepare the social and political environment at the same time that we're litigating because judges reflect the social and political environment. And of course, the NAACP didn't even ask the Supreme Court to strike down school segregation until after World War II because they knew they weren't going to win. Now, one clear cost of developing too much of a fondness for litigation, the NAACP in the early 1960s clearly was slow to cotton on to direct action. So the first reaction of Thurgood Marshall and the NAACP to the sit-in demonstrations was to try to shut them down. The NAACP had a long history of focusing on litigation and lobbying, and direct action protest was something that they did not initially support. That, I think, was a clear blind spot with the aid of hindsight. The sit-ins and the freedom rides and the Birmingham street demonstrations, those were much more effective agents of social change than a Supreme Court decision in Brown, which in fact meant very little until there was a social movement behind it that was able to enforce it. Maybe Randy wants to say something about
Just
that.
two quick things. One, your response to the first question is so sobering. If you say, well, the Supreme Court has not been a consistent champion, who has been? None of the branches of government have been consistent champions.
Right.
I mean, if you take a look at the Congress, look at the president. The president, I must say, is often, it seems to me, doesn't get enough attention. Certainly in the law school world, doesn't get enough attention. And if you think about, for instance, the importance of executive orders in constitutional law classes, you don't talk about executive orders a lot, but the Emancipation Proclamation was an executive order, really. The desegregation of the military was an executive order, Harry Truman. But I mean, the realistic response is there hasn't been a consistent champion of racial minority rights with respect to any of the branches of government. One little thing on the Warren Court. Again, in keeping with, I'm generally sympathetic to your view. If anything, I'd say maybe there's been, in your detailing, almost giving too much credit to the Warren Court. I mean, after all, in 1965, at the high point of the Civil Rights Revolution, the Warren Court brings us a case, Swain versus Alabama, that permitted facial racial discrimination with the deployment of peremptory challenges. It took another 3 decades and Thurgood Marshall's unceasing dissents for the Supreme Court to revisit that issue. That was 1965. Loving versus Virginia, the most aptly titled case in all of American constitutional history. Loving versus Virginia is decided when? It's decided 13 years after Brown versus Board of Education. It's decided at the end of the Civil Rights Revolution, 1967. The Supreme Court of the United States allowed people to sit in prison and to be prosecuted for marrying across the race line until 1967. And that's a sign of how cautious, it's, in my view, how unduly cautious the Supreme Court was. So even when we're talking about the Warren Court, we should recognize that it was very limited, extremely cautious in its dealings.
On that very sobering note, I'm going to have to begin to call the session to a close. Please join me in thanking Michael Klarman and Randall Kennedy for a very rich and provocative discussion.
Thank you, Michael.